Okay, Mr. Noel, you're up.
Good morning, Your Honors. May it please the court, my name is David Noel, and I represent the appellate Universal in this appeal. May I please reserve 5 minutes for rebuttal?
Yes, you may.
Thank you. Your Honors, just some brief background on this case. It's a scope and price water damage case, first-party property under homeowners insurance policy. Universal accepted coverage for plaintiffs' 2 insurance claims and issued a payment of approximately $15,000. There was a non-binding arbitration award, which neither party contested, and that resulted in a final judgment of approximately $25,000 for the plaintiffs in this case. So at that point, the case shifted to the attorney's fees posture pursuant to 627.428 Florida statutes. And after an evidentiary fee hearing, the trial court awarded approximately $200,000 in attorney's fees after applying a 2.0 contingency fee multiplier. And what we're here for today is to assess the multiplier. And the issue with that is that it was not supported by competent substantial evidence. Now, this analysis is governed by the Florida Supreme Court's Quanstrom case, which set forth the factors that have to be proven by an insured or a plaintiff who's claiming prevailing party attorney's fees that resulted in a contingency fee multiplier. Those are the multiplier factors. And the case law makes clear also from the Florida Supreme Court, the Joyce case, that those Quanstrom factors have to be looked at from the outset of the legal representation, not later after litigation was filed, after discovery, or after a trial if it happened. It's got to be the outset of the legal representation when the client is signed up. So, Your Honors, I want to work backwards regarding the Quanstrom factors. I'm going to start with the second factor because that one is really clear-cut in this particular case. And that factor is whether the attorney was able to mitigate the risk of non-payment in any way. And those last 3 words are critical. In this particular case, plaintiffs did not present competent substantial evidence to prove that factor. And each factor has to be proven. If there's insufficient evidence on one Quanstrom factor, the multiplier fails and has to be reversed. So this second Quanstrom factor about ability to mitigate the risk in any way, there's no competent substantial evidence to support that because of one particular document is certainly critical to that analysis, Plaintiff's Exhibit number 7, entered into evidence at the evidentiary fee hearing, considered by the trial court, referenced in her order awarding the multiplier, and that is the fee contract between the attorney and the client, the plaintiff here. And what that fee contract says is that the client will reimburse the law firm for all advanced expenses and costs. And it says those costs and expenses of litigation shall be paid by the client monthly. Well, right there, you have the ability to mitigate the risk in any way because it was written into the fee contract between the attorney and the client. Whether the attorney
is the reimbursement by the client of costs, does that equate to payment of attorney's fees by an hourly rate or some other measure?
No, that would not be attorney's fees. That would just be litigation costs, filing fees, expert costs, that sort of situation. It doesn't directly.
So exactly how does that mitigate the risk to the law firm to get compensation for the representation of the plaintiff?
Well, because, Your Honor, that particular Quanstrom factor is simply talking about the ability to mitigate the risk of non-payment in any way.
So your position is that as long as a client agrees to pay costs incurred, that's enough to mitigate and defeat a claim for a multiplier? Exactly,
Your Honor, because of the words "in any way."
Okay, I just wanted to make sure I understood that was your argument.
Absolutely. The words "in any way" and that particular Quanstrom factor, they don't require perfect mitigation of the risk or 100% mitigation of the risk. They just require some way the attorney can protect themselves. And certainly the biggest outlay or the biggest concern of an attorney is money coming out of pocket for costs and expenses. That's something you have to actively pay versus using your time. So it comes out of the attorney's bank account. And if the client is going to reimburse that and is contractually required to reimburse that, that's certainly mitigating the risk of the attorney. It's
Do you
not
have any
eliminating.
authority, do you have any authority for the proposition that mitigating the costs involved, payment of costs by a client, is sufficient in and of itself to defeat a claim for attorney's fees as a pursuant to a multiplier?
I don't have a case directly on point with a fee contract saying the client will pay costs. The case law we cite focuses on a slightly different aspect, and that's the Candelaria case out of the 3rd DCA. It focuses on whether the client can afford a retainer at the outset of the representation or whether the client can afford hourly fees. So that case law focus is on what can the client afford. And again, that's another instance where there's no evidence to support this second quantum factor because there was no evidence presented at the fee hearing as to the plaintiff's or the client's finances. And it's important to note, Your Honors, that there's 3 plaintiffs in this case, and one of them is a corporate plaintiff, an LLC. So you're not just talking about an individual, there's also a corporation there. Where was the evidence of the corporate finances or the individual finances? No evidence presented whatsoever at the evidentiary fee hearing, and that does dovetail with this contractual provision about paying fees or paying costs and expenses in the fee contract. If the client were destitute, unable to afford anything, how could they contractually agree to that provision? I think it is evidence that goes hand in hand with Candelaria that, hey, the finances here are allowing payment of something. But again,
how do you address the fact that my reading of records suggests that the Salems were of the view that there was not enough at issue where it would make economic sense for a rational person to do this on an hourly basis? How does that mesh with your theory?
So, Your Honor, that's a great question. And that particular aspect does appear at the evidentiary fee hearing. It's in the evidence, but that's not part of the second quantum factor. It's not looking towards, would it make economic sense to take on this particular case? That goes more to, do we need a prevailing party fee statute? And the case law talking about economic situation, economic amount, tends to look at that instead. That's why there's a prevailing party fee statute. Because remember here, this is a price and scope case, coverage was open, a payment was issued. If the plaintiffs collected one additional dollar from a jury or from the trial court short of a jury, they would get all of their attorney's fees paid pursuant to section 627.428. So that's always out there. The lodestar is always there providing that protection, that security blanket. The question for the multiplier is, do we take that extra step beyond the lodestar? And in this case, the lodestar was $100,000. So we're not talking about there's no compensation there. But just in terms of whether it makes economic sense, it's a claim of approximately $20,000, $25,000. That's not what ability to mitigate the risk is going to. It's a situation where the analysis is, could the attorney do something to cushion the blow here and protect themselves at the outset? And again, it's in the fee contract. There's protection built in there. And the evidence was not presented that the case law requires about the finances of these plaintiffs at the outset. So that's a complete failure of evidence on this second quantum factor. And that's fatal to the multiplier. It requires reversal and remand for entry of a new fee order without a multiplier in there. Now, Your Honors, the first quantum factor is also relevant here today, and that is the factor that states whether the relevant market requires a contingency fee multiplier to obtain competent counsel. And again, as I referenced, it's a scope and price case, coverage was admitted, payment was issued. There was no evidence presented by the plaintiffs that the Tampa legal market would require a multiplier in that situation when the lodestar is guaranteed by section 627.428 if the plaintiffs collected one additional dollar on their claim in litigation. There was also no evidence plaintiffs were turned away by any law firms, any attorneys that they sought out to take this case. Nobody testified that $100,000, the lodestar, would be insufficient for this particular lawsuit. The plaintiff did present the testimony of a fee expert, and he testified to certain different factors in testimony, and he attempted to meet this first quantum factor. But the problem is he looked at the case from how the litigation unfolded instead of at its outset, which the case law requires. And that's referenced by his testimony stating that the case was defended by an aggressive defendant. Again, you're looking at what happened in discovery, what happened in litigation. That's not the correct lens here. And that expert also testified that it was a case with a defendant who was taking a zero liability position. Again, that's also post-suit incorrect lens. Pre-suit, we accepted coverage, we issued payment. That's not a zero liability position. So the plaintiff expert testimony trying to meet this first factor about the relevant market was flawed because it was looking at it from the wrong viewpoint. It was a retroactive view instead of prospective view. Case law is clear that you can't do it that way. And that's a Joyce case from the Florida Supreme Court.
Didn't the expert testify that before the case went forward, there had been communications with the insurance company, and their response suggested that this case was not going to be one that would be readily settled or easily resolved, and that was one of the factors? And in talking to firms and other lawyers, he concluded nobody would take this case at the outset based on the position being asserted by the insurance carrier.
So, Your Honor, what happened pre-suit was that the plaintiff counsel had issued a demand letter to Universal attempting to settle the case before taking it on as a litigation file. And I believe the attorney's testimony was that there was no response to that. So that's certainly a far cry from a statement of zero liability or a statement that this is going to be aggressively defended. Nothing like that. Those all come up post-suit once we get into pleadings and we get into discovery. And I agree, those post-suit factors are what the plaintiff's expert took to other attorneys and presented and said, hey, with this situation, would you take it without the multiplier? And of course, they said, no, that's a lot of discovery. That's a lot of litigation. But again, that's not the correct lens. And there was nothing that happened pre-suit that would support that kind of analysis.
So it's not sufficient for a law firm to look at the amount of damages being claimed and recognizing that it is going to be a dispute or potential dispute as to the amount. They cannot conclude from the get-go that we're not interested in taking this case on an hourly or some basis other than knowing there might be a multiplier involved.
So, Judge, that's not the particular analysis with the relevant market. It's really looking as to whether that multiplier is required to obtain.
What was the amount of damage claimed in this case?
The final judgment was ultimately.
No, that's not what I'm asking you. What was the amount of damage originally claimed in this case?
I believe it was approximately $20,000.
So your position is a law firm who is looking at this kind of situation, $20,000 in claimed damages. When it is not immediately resolved, they meet with the client. They are not entitled to take a view that, look, if that's just a $20,000 case, we can't take this unless we get a contingency fee and there's a possibility of a multiplier.
Your Honor, I would agree with that in terms of the contingency fee, but not the multiplier. And that's because of section 627.428, the fee statute, which almost guarantees the lodestar. So you're looking at a situation, first party property, accepted coverage, payment issued, you know you're going to get that lodestar, which is $100,000. So then the question becomes, does it have to be $200,000 to sign up an attorney on this file? And there's no evidence.
Doesn't a law firm have to anticipate possible alternatives as to how the case may go? For example, lawsuit is filed, settlement is reached. A trial court might very well decline to award a multiplier. I mean, the multiplier is not a given under any circumstance, is it?
No, actually, the case law, including from this court, suggests that the multiplier should be rare and exceptional. The statute was modified to reflect that as well. There was a statutory amendment to sort of emphasize.
That amendment does not apply to this case, does it?
It doesn't apply in terms of a retroactive application, but to the extent it's a clarification of the law or just persuasive, I would think it's something to look at. But this court's own case law.
Did you make an argument in your brief that this could be applied retroactively?
No, Judge, we're not taking that
Okay.
position, but there is case
Well,
law.
based on what you just said, I thought you might be trying to take that position. So I want to be clear, that is not what you're arguing.
No, Judge, we cited the statute in our reply brief, but we used it just as an example of how multipliers are not considered to be automatic. But no, we're not saying the statute is retroactive. Regardless of the statute, there's still case law from this court that suggests multipliers are not something to be automatic. Either way, the Quanstrom factors are the analysis. So that's what matters for us today.
Mr. Noel, you're down to your 5 minutes. Use them as you wish.
At this time, I'll reserve that time for rebuttal. Thank you.
All right, Ms. Corrigan.
It please the court. I'm Jody Corrigan with Rox, McLean and Sabar, and I'm here on behalf of the appellees who are the insureds and the plaintiffs below. And the only issue in this appeal is, as we were just discussing, is whether the plaintiffs are entitled to the contingency risk multiplier. The lodestar was not challenged, and the overall entitlement to fees was not challenged. This case can actually be decided simply by looking at the standard of review. The decision to apply a contingency fee multiplier is within the discretion of the trial court, so long as there is competent substantial evidence to support the Quanstrom factors. And this court is required to defer to the trial court's factual findings. And even if you might have resolved the matter differently, you're required to affirm what the trial court did, as long as the reasonable minds could differ. This was not a simple scope and price case, and this is something we've argued throughout the briefs. Universal took a very hardline approach from before the suit was ever filed. Before Rock, McLean, and Sapar ever got involved, the file indicated that the insured had with Universal trying to get the matter covered. There was a water leak. The first water leak, Universal accepted coverage and made a payment. But in dealing with that leak, it was discovered there was additional damage. There was a supplemental claim, and Universal rejected the supplemental claim. And then there was a second water leak, and they denied coverage as to all of that. So this wasn't something where they had accepted coverage for everything. It simply didn't happen that way. To look at the Quanstrom factors, the first factor is the relevant market requires the fee multiplier. Under the Joyce decision, it's the relevant market area. It's not what the actual experience of the insured was. And in this case, there was competent substantial evidence to support this. Mr. Sabar testified about his experience at Rock, McLean, and Sabar, as well as at 2 prior law firms for which he worked, Annis Mitchell, which is now defunct, and Foley and Lardner. Mr. Schifino also testified to the relevant market, and he said that at his firm, Gunster Yoakley, they would not take a case like this absent of the benefit of a possible contingency fee risk multiplier. And he also consulted with 4 other law firms in the Tampa area. And all of them said that they would not take this case. As for the perspective of the lawyers that he spoke with, they were not looking at it retroactively in the manner in which the case had been conducted. They were looking at it from the outset of the case. We already knew from before Rock, McLean ever took the case that Universal was fighting this. And that was how Mr. Schifino asked the other lawyers. It's clear from the transcript, he was asking, would you have taken this case absent a fee multiplier? And the answer was no. Universal's expert, Mr. Nicholas, testified that a multiplier was not warranted, but he really didn't have any evidence as to what the market would bear. He basically said that because of the scope of Zoom these days, that the relevant market was much broader than the Tampa area. And he also said that there was a lot of billboards in the area advertising lawyers. He did not point to one law firm that would have taken the case without a fee multiplier. He didn't point to one billboard that actually said we take these types of cases on the basis of having not having a fee multiplier. So there's absolutely competent substantial evidence to support the first Quanstrom factor. As to the second factor, the risk of non-payment, the fee agreement and its compensation for costs, which it actually was not evidence at the hearing because nobody brought it up at the hearing, There's no evidence that the firm was ever actually paid for any of the costs, but that cannot compensate for the risk of non-payment. And the reason is the costs were minimal. The costs, I believe, were it was about $11,000 of costs reflected in the final judgment, and there was about $100,000 of fees just on the lodestar amount. So compensating for the cost, yes, that's something that the law firms would have to spend out of pocket, but it doesn't compensate for the lawyer's time. And I think Mr. Sabar testified quite clearly that what do we have as lawyers? We have our time. We have the time that we spend on the cases we work on. And as a firm that generally practices in an area where fees are charged by the hour, giving up the time where you're guaranteed to be paid is very different from just agreeing to be compensated for some of the costs. So anyway, back to the second risk factor, the risk of non-payment. In the briefs, Universal relied predominantly on the Candelaria case, and there were two first district cases cited in that case. I believe it was Weston and Eckhart. And they said in Candelaria, which is third district, said that the controlling consideration in determining whether an attorney can mitigate the risk of non-payment under the second prong of Joyce or the Quanstrom factor is whether the plaintiffs can afford a retainer or hourly fee. But if you go back to the Joyce decision and look at it, the court never said that. The Florida Supreme Court, it addressed the second factor in one paragraph where it simply stated, and I'm going to read it, to the second Quanstrom factor, the trial court found that the Joyce's attorney could not have mitigated the risk of non-payment. The court relied on testimony from the Joyce's attorney that the Joyce's told her they could not pay a retainer, as well as the testimony from the Joyce's fee expert that there was no meaningful way to have mitigated the risk of non-payment in this case. That's all that Joyce said about it. So it's really, Candelaria kind of went a little further than what the Joyce court had said. And we cited in our briefs the SOS State Farm case, which is a Middle District of Florida case, which basically said that you could take into account economic factors. Basically, that in a small claim, it would be unrealistic to expect an insured to pay an hourly rate and thus bear the full cost of litigation, regardless of outcome. We also had cited the Liguri case, which is our third district from 2018. And in that case, it was cited in the motion that a trial court generally can rely on expert testimony that a party would have difficulty securing counsel without the opportunity for a multiplier. And also the Bell case, which is cited within Joyce, and we also cited it in our briefs. And it says the multiplier encourages plaintiffs to bring cases that would otherwise be economically unfeasible. And that's exactly what we had here. We had a case that was economically unfeasible. Sabar testified that the client asked him to enter into a contingency fee agreement because the economics of paying to litigate the case on a normal hourly basis were simply not feasible. To bill hourly, the fees incurred would greatly eclipse the amount of the money at issue, and therefore it was not economically feasible. Mr. Schifino also testified that the only mitigation of the risk of non-payment in this case is essentially to win. And for the record, the trial court at the end said that she could not think of any other case in which anyone had ever asked for fees that she felt like they were more clearly entitled to than in this case. I think I've addressed your questions, and I know I didn't speak very long, but if there are any more, I'm happy to address them.
I just wanted to check one thing. The fee issue came up based on a proposal for settlement or an offer for judgment. There was no request for appellate attorney's fees, correct?
There is a request for appellate attorney's fees.
Our docket doesn't seem to show that, so you may want to double check and verify when that was filed.
Absolutely. We did file it, so I'm not sure why it's not showing, but there is a request in there.
Very good.
And the attorneys, that was another thing that was brought up in, I believe it was in the Joyce case, is the fact that there had been an offer of judgment served in that case that showed that it was, the insurance company was going to fight it, and that showed a belief that the insurance company would prevail. That was the same situation in this case. Universal had filed a proposal for settlement for $500, which indicated that they were clearly going to fight this out, and they did.
Do you recall by any chance, did you file the motion in connection with the answer brief or later?
it should have been in connection with the answer brief. I don't have the docket right in front of me to be able to pull it up.
All right, we will check that. But right now, it does not appear to be in our docket.
I may have it in a second. I don't have it, but we'll check on that, absolutely.
Very good. Thank you very much.
Thank you.
Okay, Mr. Noel.
Thank you. Your Honors, I want to address the economic feasibility issue again, because that was brought up in the answer brief. It's been brought up today, and we squarely addressed it in our reply brief. And we pointed out that the case law relied upon by the plaintiffs here, in particular, the Bell case and the Roe case from the Florida Supreme Court, those are both linking economic feasibility to the availability of a prevailing party fee statute. If you don't have any way to get fees from the other side by winning the case, then it's impossible for an attorney to take a small claim and litigate it. They can't get the fees back except from the client, and nobody's going to pay $100,000 to litigate a $20,000 claim. That's not our situation here. We have the prevailing party fee statute 627.428, and that resulted in a lodestar of $100,000. I do want to quote that case language because it's important from the Bell. This is the Florida Supreme Court in the Bell case, 1999. We recognized in Roe that the availability of attorney's fees would have the effect of encouraging plaintiffs to bring meritorious claims that would not otherwise be economically feasible. So again, that's nothing to do with the multiplier. Same thing in the Roe case. It can be argued that rather than deterring plaintiffs from litigating, the prevailing party fee statute could actually encourage plaintiffs to proceed with well-founded malpractice claims that would otherwise be ignored because they are not economically feasible under the contingent fee system. So what those cases are really saying is that where you have a prevailing party fee statute, you're fixing the economic feasibility issue, because that's a way to recover at the end of the case that's completely divorced from the amount of the claim. It's not a multiplier situation. We still have to be bound by the Quanstrom factors here today. The SOS case that counsel had cited, it's also in the answer brief. That's a district court decision. But what's important about that case, and I want to quote from that case from SOS or SOS, it states, the retainer agreement between the client and his attorneys made clear that the client would not owe any fees, costs, or expenses in any form if the case was unsuccessful. That's not like our case here today. We have that provision in the fee contract that requires the client contractually to pay for expenses and costs. So SOS is dealing with a case where there's no protection there whatsoever. There's no situation where costs or anything like that have an ability to be mitigated in any way. So again, SOS also being a federal district court case, but it's not like our case. None of these cases would support this contingency fee multiplier. This court's Wagner case is in particular an important one to take a look at, because that case held that a fee multiplier is not a surrogate for a sanction, and it should not be applied based solely and in hindsight upon how far along in the civil adjudication process a particular case happened to be resolved. So it's really reinforcing that we don't look at how the litigation went. We look at the outside of the case. And at the outside of this case, there's a fee contract saying, client, you're going to pay costs, you're going to pay expenses. That's certainly an ability to mitigate the risk of non-payment in any way. Also in the Wagner case, that was the decision I was referring to earlier about how multiplier is an exception, not based on the statute. This is well before it, 2016 case. The Wagner case, this court stated, the application of a multiplier is the exception, not the rule. We can't just apply a fee multiplier in every contingency fee case. Any of these cases, an attorney can argue, well, we wouldn't have taken the case without a multiplier. We're taking risks. We could lose. That's why there's the prevailing party fee statute. That's why there's the lodestar. And in this case, the lodestar was 5 times the amount of the claim, 4 times the amount of the ultimate final judgment. There simply wasn't a basis in the evidence to double that fee award when the Quanstrom factors were not proven by the plaintiffs, and they're simply not in this record in a sufficient way that would allow this fee order to stand. So your honors were requesting reversal and remand for entry of an order without a multiplier that's supported by the case law. The answer brief has not disputed that would be the correct relief if we prevail. And for those reasons and the reasons in the brief, we do request that relief. Thank you.
Okay, thank you both. In order to leave our virtual courtroom, you need to click the leave button or icon in the lower right-hand corner of your Zoom screen. And when you do that, we'll be done.